Hey, Fred.
Hey, Arthur.
We're not going to see as much of you as of midnight. If we're still working as of midnight, we got to get in our cars and drive over together.
I'm 3 hours away, so I'm not driving.
Yeah, you won't see much of me after midnight.
Here's Arlene.
Hi, Arlene.
Hi. Hello.
Okay, everything is ready, Charles.
And Arlene,
Yeah.
I'm going to ask what the two lines that Joseph uses at the beginning is, have all notices been, issued, and what else? And the meeting's being recorded, but
Well, yeah, you don't have to say that because we're live on Zoom. Yes, you
Yeah,
just have
okay.
to say about, this is going to be our last Zoom. So, and we have to be done by midnight. Otherwise, we have to just.
we all turn into pumpkins. Okay, are we ready to get the show on the road?
Ready to go.
We are.
Okay, so if you can let everyone in, and once they're in, I'll read that executive order statement to get us going.
Oh my God, how are we going to fit everybody?
Welcome, everyone. My name is Charles Canham. I'm going to be the acting chair tonight because Joseph, our intrepid leader, is out this evening, I think, for his son's graduation. Is that correct?
Yes.
Congratulations to them. I would like to, I have to read an opening statement because this meeting is being held online, subject to governor's executive order. And so I have to read this opening statement that tonight's meeting has been convened in accordance with the governor's March 13th, 2020 executive order 202.1 as extended, which suspends certain provisions of the open meetings law to allow the ZBA to convene a meeting via video conferencing. In accordance with the executive order, the public has been provided with the opportunity to view tonight's ZBA meeting via this Zoom link or via YouTube, and a link to the town's YouTube channel has been provided in the meeting notice. A transcript of the meeting will be provided at a later date. I'd like to ask I will just read off the names of the zoning board members and just ask them to wave or make note when I do. Russ Tompkins, Ron Mostello, John Calogero, Norma Dolan, and Arthur Weiland. Okay, so we have a busy schedule tonight. My apologies to those of you at the bottom of the list. It's going to be a while. We have 5 area variances to consider, and I will let's just go ahead and jump right in with the Merck Hill area variance. Let's see, who is here representing this applicant? So Rebecca Vall, is that correct?
Correct. Good evening.
Okay, if you could just briefly describe why you're here for the board.
Sure, and I apologize. My furry little friend just started barking in the background, of course, as it's time for my presentation. If I may, is it possible if I can screen share to?
I have it. I have it.
You have it? My submission?
Yes. Which one do you want to share? Which one?
Well, my letter, I was going to go through the images as I spoke.
Well, I have the photos. I could, let me show you what I have. I mean, you could start by saying what you're trying to do.
Okay. Oh, I see that I can screen share now, actually. So, because.
Here's what I have.
Yeah, I was going to go through my my letter. If it'd be possible for me to share, I can show
Yes,
the
go
photo.
ahead.
Okay. All right. Can you see now the image? Okay.
Yes.
So good evening, acting chairman and members of the ZBA. My name is Rebecca Volk with the law firm of Cuddy and Fader. On behalf of Merck Hill LLC, I'm joined this evening by Elizabeth Cobb, who is a member of the LLC. We're here this evening for an area variance from section 250-29B6 of the town's code, which limits the size of an accessory dwelling to 1,000 square feet. Before discussing the variance, a background on the property and events leading up to this point is necessary to put the application in context. The property, as you can see here on the screen, is a 31.61 acre flag lot that gets its access to Rimpf Road by essentially a 43-foot wide flag pole. The property was purchased by the applicant in December of 2019, and at that time, it's in significant disrepair. It's obvious that the property had suffered neglect and poor treatment. The pool house had a kitchen downstairs and a bedroom and bathroom upstairs at the time of purchase. The applicant did their due diligence at the time of their purchase. They had title work done and a municipal search, and a CO existed for the pool house, noting that a variance had been granted for the same. Now, this is not a criticism, but the CO didn't indicate the restrictions, so nothing really triggered a concern that any of the improvements in the pool house may not be legal. The closing proceeded, and about a year or so later, the applicant sought building permits for both structures to make improvements, and that is the time where the restriction on the accessory dwelling unit was raised. A review of the file then uncovered the 1999 variance minutes, showing that the pool house had been approved as an accessory structure, but not as an accessory dwelling, with certain conditions at the time. It was actually approved as the sixth accessory structure on the property. And here, as we see the property, I've highlighted for you the garage. This is the main house. The pool house and the pool that is the subject of the application is this structure right here. And then just a little bit closer to the edge of these properties here, you have the tennis court. So when the issue came up with the pool house, the applicant found the 1999 minutes. And we don't dispute that, unfortunately, what the concern of the 1999 ZBA, that a prior owner would go ahead and make the improvements without approvals, that occurred. There's no, we're not denying that fact. What the applicant is here now to make it right, legalize this as an accessory dwelling. Pending this application, the kitchen and the second floor bathroom have been removed. So the pool house has currently been returned to its permitted state at this time while we proceed before this board. So the variance would be to permit an accessory dwelling that has a total square footage of 1,859 square feet, where 1,000 feet is permitted under the code. Now, just briefly, you may all be familiar with Rimpf Road, but this particular spot shows the access to Rimpf Road. And you can see here two homes that are set back, fairly good distance from Rimpf Road. When you look at the Google Earth image, these are those homes you see from Rimpf Road. And this is the applicant's property. And here, where I'm pointing right now, is the pool house, just to give you a sense of how very far back it is set from Rimpf Road, and also how well it is screened from other properties. So as the board members, I'm sure, are aware, when you consider an area variance test, you consider 5 factors that are found in the town law. No one factor is determinative. The applicant does not have to meet all 5 factors. The task of this board is to respond to each criteria, balance the responses, and make a determination that you feel is warranted. So the first criteria is whether or not the application is going to result in a change in the character of the neighborhood or a potential detriment to nearby properties. We would note that the pool house has existed in its current location since 1999. There is no proposal to change the footprint of the pool house. I actually don't know if there's any exterior plans at this time, but that would be, appearance changes and not footprint changes if there are. Also, I would note that, as stated, it is screened. I believe this is from these homes to the pool house is a distance of approximately 900 feet. And the distance from Renf Road is over 1,200 feet. As you can see, there are excessive trees that provide screening so that this is not viewable to anybody who's traveling and observing the character of this road. And again, it has existed for 20 years, so the character is already established in the sense of the building and the structure. The next factor in the variance criteria is whether the benefit sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. As I've quoted in my submission letter, your code discusses that if an accessory dwelling is over the 1,000 square feet, then it becomes a second residence and the property should be subdivided. But this property is unique in the fact that it cannot be subdivided under your code. This frontage meets the minimum for only one lot in your zoning district. So it is not possible to create a separate lot given the configuration. The only solution would be for a variance to create two entrances of frontage. And I think that would be more of an impact than a home that is set on a 31-acre parcel, which is approximately 6 to 10 times larger than your minimum lot area in the zoning. I say 6 to 10 because there's a little discrepancy on whether this is in the AR3 or in the AR5. The zoning administrator's letter said AR5, your public hearing notice said AR3. I noted this in my cover letter from the zoning, your zoning map in color. Lot lines are not shown, but the best I can tell is it appears that your AR3 zoning district may end roughly at the end of this flag, and this may be, I'm sorry, AR5, and this may be in the AR3, if I have that correct. I'll have to check the footnote, but either way, it is somewhere between 6 to 10 times larger than your minimum lot size. So the next criteria is whether or not the requested area variance is substantial. And it is very common that, that folks looking at this criteria will get caught up in the math of the question. But really, whether or not a variance is substantial has to consider all of the facts and circumstances. And substantiality is not solely a matter of a mathematical proportion. We would submit that while the square footage is, as the planning board had said, 80% more, you have to put that in the context of a property that is so much substantially larger than your minimum lot size and cannot be subdivided. So you're not running the risk that an applicant would attempt to, say, for example, subdivide the rear and keep this as an accessory dwelling on a smaller lot. This cannot be subdivided under your current regulations. That is also a reason why this application would distinguish this from anyone who would say that this is a precedent of potential future applicants because of the lack of ability to subdivide. The next criteria, number 4, is whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. Again, there is no proposal to enlarge the pool house. Any upgrades and improvements will be within the existing footprint. This action is type 2 seeker exempt, so there's a presumption that there are no environmental impacts. So I would submit that the record has absolutely nothing to believe that there would be any impacts. And then finally, the fifth criteria is whether the alleged difficulty was self-created. But as the statute says, the consideration is relevant to the decision of the Board of Appeals, but shall not necessarily preclude the granting of an area variance. So again, when you consider the other four factors and you balance those, I believe the scales tip firmly in favor that this variance would be appropriate given all these facts and circumstances. At this time, I would ask if any of the board members have any questions.
Thank you, Ms. Volk. Why don't you, well, actually, I'll turn it over to Arthur Weiland to lead us in initial set of questions and comments.
Would you like
Arthur?
me to stop sharing my screen, or is it helpful to have?
It's probably a little easier. I think we all have that and we can use parcel access, so.
Okay.
Yeah, and I wanna show the pictures because we have public hearing. They want to see the pictures of which and which, you know? With,
If
the blue houses.
show them, but don't leave them up for
Yeah,
a too
yeah,
long a
yeah.
time. That's great.
Or I could show it when the public is open.
You know,
No,
I
it-
think- yeah, okay. Because I would rather speak to the board and let
Sure.
other folks also see. Unfortunately, I'm not sure if we have the proper authority to act. I understand I have the submission that Arlene sent. I'm just pulling it up now. What was it for? About 5 o'clock.
I have it. You want
Yeah.
me to pull it up?
You can put that up if you want. I don't know. I assume the other board members got it too. I'm not sure. Yeah, everybody got it. All the board got it. So I don't know that we need to see this submission immediately, but you're going to put it up.
Can you see it?
I understand that Elizabeth Cobb has authorized Rebecca Volk to be representative in this issue, but I don't see how the LLC, which to my knowledge contains more than one individual, has yet given the authority for this action.
There is only 2 members of the LLC. If the ZBA requires signatures from both, we will submit signatures from both. I just note that's not an attachment to your ZBA application. This was raised on the phone, and I did, as Ms. Cobb is a member of the LLC, obtain her signature. She unmuted her microphone. Elizabeth, if you want to speak to that.
Yes, so the other member of the LLC is Matthew Cobb. I have signed authorization to act on his behalf. I believe it was from a month or 2 ago when we thought the hearing was going to happen, but we do have that and we can submit it to you.
Yeah, I think I will take a moment and add that as a condition should we will be acting on the variance in one way or the other. And to have that as a condition to finalize the variance if it's approved. Just a procedural step.
No objection.
I'm going to take a moment, if you'll forgive me, to call up the document. Oh, I have a lot of documents here. I apologize. And I do apologize. I thought I had that right.
You want to start with the planning board recommendation, Arthur?
Well, I will only have to come back to this. Again, I have another issue. Sorry. I was told I should put new batteries in my mouse earlier today, which I haven't done yet. Oh, I do regret that let's see, I should be able to call this up pretty quickly. You should mute me while I hum. Oh, I am in the right folder. And I have called up the document. Come on, load. Apologies for And okay, thank you very much. Planning board. I can now do the planning board recommendation gladly. April 23rd is the date of the planning board letter sent to Elizabeth Cobb, addressed to her, and starting at the town board, Town of Clinton Planning Board meeting held on April 20th, 2001 regarding the above subject application. The following motion was made. Mr. Carroll motioned that the Town of Clinton Planning Board is making a neutral recommendation to the zoning board of appeals on the requested variance to section 250-29 regarding the habitable space square footage of an accessory structure that the applicant is seeking to convert into an accessory dwelling, requested by Merck Hill LLC on the property located at 77 Riff Road in the Town of Clinton, parcel number 803790 in an AR3 zoning district. I just went to parcel access, and parcel access lists it as AR5. So we're just gonna have to read on with this letter. Sorry about that. The applicant is seeking an area variance in order, whereas the applicant is seeking an area variance in order to convert an existing pool house into an accessory dwelling. It was number one. Number two, the property is a flag lot on 31.61 acre lot in an AR3 zoning district. The property is not within a ridgeline scenic and historic protection overlay district. The property is not in a critical environmental area. That was 3 and 4. 5, the variance requested is substantial as the existing accessory structure square footage of 1,859 square feet is almost double the maximum of 1,000 square feet. I've seen a different number elsewhere, which is in my motion. I don't know where I saw that. I had 1,900 and something. Anyway, we'll deal with that in the future. For an accessory dwelling under section 250-29, the approximately 86% increase over permitted square footage was the primary concern of the planning board that weighed against the positive recommendation. The planning board found that other relevant factors with respect to accessory dwelling weighed in favor of the applicants, including that the proposed accessory dwelling is clearly subordinate to the use of the principal house, comma, the dwelling will be within the footprint of an existing structure, comma, the owner is a full-time resident of one of the main dwellings, which is confusing. I think there is only one other dwelling on the property. That's an aside for myself, period. Let's see. Pardon me, I'm looking for, oh, comma, not period. The number of bedrooms is within the limit of 2, comma, the building is consistent with the character of the existing buildings and neighborhood, comma, and the total acreage of the property is over 10 times the required 3 acres by this document. Let's see, number 6, an undesirable change will not be produced in the character of the neighborhood or be detrimental to nearby properties as the accessory structure will not be visible from the road or neighboring properties. 7, the benefits sought by the applicant cannot be achieved by some other method without demolishing part of the existing structure. 8, the proposed variant should not have an adverse effect on the or impact on the physical environmental conditions of the neighborhood. 9, the alleged difficulty is self-created but should not necessarily preclude the granting of the area variance. 10, the applicant has filed or will file an application for special use permit which shall be considered by the planning board separately. Okay, I think the board may, certainly I emailed the board with my motion. And you can see there are a few places where I don't agree with the particulars of the planning board, but I think the planning board made a lot of good points. Done.
And let's see, there was at least one letter submitted about this. Do you want?
Certainly
want to-
two. We have one from Mr. Brands of, I think there are two. There's certainly one.
Yeah,
Mr.
I
No,
thought
there's
there
two.
was two. The
Yeah,
other one was submitted before, last month.
I have it on my computer.
Yeah, last month, remember?
Thank you. Mr. Brands of 1215 Center Road, Rhinebeck. Dear Chairman, I happened to see the enclosed notification of yesterday's paper regarding an adjoining property owner who apparently wants to convert a structure into an accessory dwelling. Unfortunately, I am leaving this area for a few days and will not be around to research this further so far as what is being asked for. I want to express an opinion in general regarding requests to add additional dwellings to properties in our town. Putting aside whether a variance is even justified, my concern is utilization of properties for uses such as Airbnb on small, quiet country roads such as ours. In that regard, should the board consider approving additional living area for any properties on Renf Road, I would ask that restrictions prohibiting rentals for less than 1 year be considered. And it's signed and dated May 20th, 2021. Let me see if I can find that other, get to my email and get that other, I don't know.
It's from Joseph Clazen and Anya Romanoff. From
I understand, but there are quite a few emails at 10:15. No, that's Dale Lesko. That's the different one. I don't know exactly the time and date on this, so I'm just searching through the recent 10 or so emails. This may be it here. I think this is it. Yeah, 7. This is the letter. And here's the letter attached to Joseph Mulcarney, Chairman, from Joseph Clausen and Anya Romanoff, 41 Renf Road, Stafford, New York. Dear Chairman, we have become aware of an application for an area variance on the property at 77 Renf Road, tax grid 803790. We understand that the applicant Merkill LLC is seeking a variance in order to convert an existing structure, brackets, pool house, close brackets, into an accessory dwelling. While we do not wish to interfere with our neighbors' enjoyment of their property, given that the application does not say for what purpose Merkill intends to use the accessory dwelling, we wish to express our general concern about the possibility that accessory dwellings could bring increased noise, traffic, and other forms of disruption to quiet country roads like ours. Unfortunately, short-term renters often are not invested in maintaining and respecting the character of the neighborhood in which they rent, period. As owners and residents who place a great value on the peace and quiet that prevails on Renf Road, we worry that the coming and going of short-term renters could compromise our enjoyment of our property. We therefore support the suggestion made by another neighbor that if the ZBA decides to grant the requested variance, it will consider imposing a restriction that would prohibit rentals for periods of less than a year. Thank you, sincerely, signed by Joseph, it looks like. It's hard.
Thank you.
Signatures. Yeah, but anyway, they type both owners' names.
Thank you. So, before we get into a public hearing, do other members of the zoning board have questions for the applicants or comments?
I'll make a comment. The only thing that bothers me is reading back over the minutes of when this was originally built. There were board members at that time that had concerns about it. And obviously, somebody turned around and did exactly what they were afraid would be done, turned around and put a kitchen in, turned around and made it a dwelling. And now it seems that the new owner, who had apparently nothing to do with this and unknowledgeable about it, has something that really zoning was trying to avoid all along. It was trying to avoid larger than 1,000 feet. And like I say, somewhere along the line between it was built and the current owners, the people, how could I say, secretly turned around and did exactly what the previous zoning board of appeals was afraid of. I think, you know, in the future, maybe pool houses should be limited in size so that this can't happen again.
I do have one question for the applicants. The property card lists the square foot living area, which is not the same as the footprint, but is typically larger than the footprint if it's a multi-story building, of 1,598 square feet. Your application gives a number of 1859, and then Arthur has 1914. So we ought to figure out exactly, make sure we have the right number here. Arthur?
I'm going to ask William Cornwell, who is
May I
the
speak,
applicant.
May I speak, please?
Yes.
He addressed me. Thank you. I was sitting in on that meeting, and what we did to help the applicant is inform them the difference between enclosed space or footage and habitable space. So a certain amount of the interior space was taken off the habitable space concept. That's what my memory is bringing forward.
I just wanted to make sure we had the right number on the variance.
I'm going by their application, I think, with the 1900, but I will check while the Miss Volk
Yeah.
responds as she wanted to.
Yes,
Thank
thank
you.
you. I apologize. I thought that the acting chairman had directed the question towards the applicant. I do have Bill Cornwell, who is the applicant's consultant on the construction here, who can speak to that. I do know that Mr. Fenton's zoning determination letter had the larger number, but I believe that that was refined. And Bill, are you able to add some details on that?
Yep. So I'm the designer on the project. And so I went and did an as-built drawing. And so I have in my CAD program, the downstairs is 1,510 square feet, and that is total square footage. So that's not habitable space, that's total square footage. The second floor is 349 square feet, because the vast majority of that building is only the ground floor. There's just like an upstairs, what was supposed to be a storage loft, but ultimately ended up housing a bedroom and bathroom. So, you know, 349 square feet plus the downstairs comes out to 1,859 total square feet, not habitable.
Yeah, our zoning law contains a number of different definitions of size, and the revision that's being considered is trying to standardize those. It gets quite confusing. I just wanted to check this section 250-29, because it talks about 35% of habitable space or 1,000 square feet of floor space, which are not always the same thing. So I think as long as the number you're asking for covers what you propose to build, I think we'll be fine. I just want to make sure, and so we can proceed and try to make sure we have this number correct. Any other questions from board members?
Well, the property card, if my listed as AR5. So don't we have to go with the official records of the town?
I
Well,
would.
When you say property card, do you mean parcel access? Because I have found numerous situations where parcel access is in error. Typically, the zoning map is the best source for that information. And just to read my review of it, in color on your website, it appears that the entrance or flagpole to the property is an AR3, while the balance is an AR5.
And we certainly want to get this correct in the language here, although I would note that given the size of this lot, whether it's an AR3 or an AR5, to me is not a big issue. Norma, are you, what would you propose that, it's entirely possible that a parcel could straddle this. And so, and that I've never seen it.
Can you put both?
I just wanted to, excuse me, I'm addressing the chairman. I just wanted to agree on something, you know.
Yeah. Arlene, do you?
Can you put both AR3 and AR5?
So,
We could do 3/5.
Or an alternative is where the structure is located appears to be an AR5 would, yeah.
and we can work on the language in the motion to capture this. If there aren't any other questions, can I get a motion to open the public hearing?
Seconded.
All in favor?
Aye.
Aye.
Great. So do we have anyone who wishes to address the board about this application? And I'm not sure I can see, let me make sure I can see everybody. I guess I can. So if there are no comments, I'm going once, going twice. Oh, sorry, yes. Please, you're muted. There
Sorry,
you go.
my name is Bonnie Fulmer and I don't live on Roof Road. I live on Schultz Hill Road, but still in the town of Clinton. And I just kind of want to second what Mr. Brand said in his letter and the other letter that you referred to, that I am concerned about the purpose of this pool house, whether it is going to be in fact a pool house or an Airbnb or whatever. I can speak to the fact that within the last 3 years, we've had 5 Airbnbs pop up on my road between the mile that stretch where I live. I think some of them may in fact be illegal. I don't know, but regardless, it has changed the character of this corner of the town of Clinton, and not in a good way. And I would like the board to be cognizant of that and be very careful. Like Mr. Tompkins said, I think the original intent back in 1999 was to stop from happening what in fact already has happened. And I'm concerned about expanding that any further. I don't know if it's my right to even ask this, but I'm curious about the size of the pool house in comparison to the main house that's on the property. I mean, is the main house like 20,000 square feet and a 1,800 square foot pool house seems, or is it really a second dwelling on that property?
Well, I think if I can respond and the applicants can fill in. In effect, the request is to create an accessory dwelling unit. When we typically use the term pool house, there's no bedroom. We have decided that bathrooms are fairly essential for pool houses over the years. And it took us a while to get there, but that's where we are. But full kitchens, for instance, would not be allowed in a pool house. So this is intended to be a place where someone can live, separate from the main, the principal dwelling, which is not an enormous building. According to the property card, it's only a little over 2,000 square feet. So Ms. Falk, is that, or Ms. Cobb, is that accurate, or?
It's actually, the main house is actually 3,711.
Okay, so maybe I haven't scrolled down, whether there was an addition.
You did, yeah, no, and it's the same problem with the pool houses. The numbers, as Ms. Volk mentioned, my property card is way off too.
Yeah, okay. So there is a much larger, a substantially larger principal dwelling unit on the property. Any other comments from you? And thank you for those. Bonnie, I guess I don't know your last name, so I can't address you more properly, but did you have other comments?
No, I like Mr. Brand's idea about 1 year minimum rentals on
Okay.
additional dwellings. That's all. Thank you.
Any other questions or comments from the public during the public hearing?
Maybe you could ask the owner what's their intention. It will kind of like give the public peace.
That makes sense. Please go ahead.
I'm happy to address this concern. And as a resident of the town, I would frankly share it. I am an only child and I have 2 aging parents. And we bought this property with the intention of them coming up to live here. And this is our full-time residence. We're not just here during the summer. We really wanted to be a part of the community. This is very important for us to be good neighbors, and we want to make this right. So renting is not on our radar at all. And I completely understand your concerns, and thank you for raising them.
Thank you. Any other questions or comments from the public? If not, I would like to move that we close the public hearing.
Second it.
All in favor?
Aye.
Arthur?
Aye, yes, yes.
Thank you. So, any further comments from the board or questions?
I'd like to point out that the town does have a short-term rental law now. It is very restrictive or not restrictive enough, depending on where you sit on the issue. But you should get a hold of a copy of it, read it, and inform yourselves as to just what the nature of that law is. And anyone proposing to have a short-term rental has to follow the guidelines within it. And there's no question that it brings change to the town. It has brought that change to Rhinebeck. It's brought it to every town where it has occurred. And most notably as well, New York City has been struggling with this. So this is something ongoing that we're all going to have to face in the future. And there are very positive sides to it, and there are very negative ones as well. So read it.
Yeah, thank you. Okay, others, any other? If not, Arthur, do you want to present your motion?
Certainly. I'm going to take a minute. I made a short note on the condition. Thank you for your patience. All right, here we go. I would like to, yep, ready?
Please.
All set, off and running. I would like to make a motion that we grant to Merkill LLC of 77 Rimpf Road, number 803790, a variance from section 250-29 accessory dwelling units. The maximum 100 square feet to, I'm going to change this to what the builder, may not be quite the right term, 1859 square feet, 1859 square feet. I have to make a little edit here. Oh, come on. There we go. Thank you. Number one, a change in the,
Of,
what?
of,
Yeah, a change in the physical conditions of the, thank you. Physical conditions of the neighborhood will not be brought about since the building was constructed in the early 2000s at its current size with the proper relative square footage in relation to the principal structure on the property. In relation to, okay, you know, I did read this 3 or 4 times before I sent it. Number two, the benefits sought by the applicant can be achieved by either reducing the habitable space or granting the variance. Structurally, reducing the habitable space would be detrimental to the aesthetics and monetary value of the property. The variance is substantial. I have to change the percentage to, or is it 85.9? 85.9. The property's prior physical condition is being substantially improved, and currently the only foreseeable adverse effects on the physical or environmental conditions in the neighborhood would be the unknown but foreseeable increase in traffic expected with the parameters of expanded use of the property. The alleged hardship was self-created due to the desire to have more living space within the guidelines of Clinton zoning code. Residential area variance does not require an ag data statement. A residential area variance is a type 2 action under seeker. The site is in a CEA district. The site is not within the boundaries of a buffer or wetland. The site is not in the ridgeland, scenic, and historical overlay district. The site is on a scenic and historic road, Renf Road. Previous owners' zoning violations have been removed, and there are not any known current zoning violations. I'll pause for a minute before I go to the conditions.
Second for discussion?
It's not, I'm not done.
Oh,
Oh,
what are you pausing for?
I want to, there's something I want to address briefly. Oh, number 9, the site is not within the boundary or buffer of a wetland. I just wanted to mention that's sometimes a little confusing. The overall site has wetland. The site of activity is not within it or near a buffer. So that is a little confusing to me sometimes. All right, so the motion continues with conditions. All of these conditions are conditional, and I would expect the board to discuss them. Condition number 1, the pool shall be fenced off from the accessory dwelling unit, upgraded to the code 250-74A. A latch is not a lock. A lock requires a key or code. Condition number 2, accessory dwelling unit will have only 1 bedroom. If used for income, it will not have any other sleeping areas for adults, brackets, people over 15. Some other type of bracket I used, intended to limit the number of drivers in the residence. Condition number 3, rental shall be by 1-year lease or greater without sublets. Condition number 4, signature of the LLC, members to authorize shall be obtained and presented. I'd just like at this point to mention that although condition number 3 talks about a 1-year lease, I only put it in there so that it will be discussed as the residents have expressed their concern. Thank you, done.
Second for discussion.
second,
Thank you, Russ. Discussion from board members. Norma?
Regarding the subject of the property not being able to be subdivided, And that's a planning board process. We do have a flag lot that was subdivided by sharing the driveway. And since we're not in a position to make that determination, I would like to see if the other board members agree that that be put down as a condition and perhaps even be added to the deed if the board members feel that we've had that done before too. Just because it seems acceptable to the owner and applicant.
It would be the responsibility of the planning board if this should come forward for subdivision to realize that part of the subdivision would be a double-sized portion for these buildings, I believe. That would be their responsibility at this point. I agree. Initially, I agreed with Norma, and I was looking for, I actually asked Ms. Volk if there was a survey, I think, or maybe I asked Elizabeth Cobb if there was a survey, because we've done it by putting the survey, changing the survey map. Deed maybe just as adequate. I'm sort of agreeing with Norma's concerns, although I do think the major responsibility would be the planning board in the future.
Yes, but since our decision tonight is based on, in part, by that understanding, I just don't see the harm in putting it in writing and carrying it forward from the 1999 minutes.
Chairman, please let me know when I'm able to just address some of the comments. I don't want to interrupt any of the board.
Yeah, no, this would be, I was just about to ask if you or the applicants have a comment about this.
Well, as to the question of subdivision, I would suggest that perhaps a reasonable would be that this accessory structure would essentially have to be essentially ripped out if there was ever an intent to subdivide the rear portion in the future. The goal is that we're saying that it can't be subdivided under the current code. There's no intention to subdivide it. And I understand the town's position that they're considering this variance with how large this property is. But I haven't discussed with the client whether or not she'd want to restrict it in perpetuity for subdivision. So we would agree to a condition that this has to be ripped out before any potential subdivision. I also would like to address the condition on the 1 bedroom. I'm a little confused about, given that the code permits 2 bedrooms and accessory dwellings, why that would be appropriate. The plan is to have 2 bedrooms in this structure. So I'm not really seeing the connection between the bedrooms. I understand there was something about cars, but the basement or the first floor of this is very large. That's not going to control how many people come to this as an accessory dwelling. And as to the short-term rental, the client has no intentions, and you do have a law that requires the permitting. We would agree to a condition that the variance is essentially voided if there's found to be a violation, but I don't want to prevent it because, again, a short-term rental is something in the purview of the planning board, whether or not it would be appropriate. And you do have a very thorough law that the town of Clinton spent a good year determining what the appropriate standards were.
Thank you. So thoughts from the board about Arlene?
I just want to say, with regards to the condition, the STR, they do the number of people. So not unless this is just a regular rental. I'm talking about the condition about limiting the number of the sleeping areas for adults. They normally, when they review the STR, how many people can they have it rented? 4 people normally. It depends on the number of bedrooms. So
Okay.
this question.
Okay, thank you. Yeah, how are, where do other members stand? The factors seem fairly straightforward. I think most of the discussion here is about the conditions.
I
I have several comments. I mean, I'm looking at this, and like I say, this came up because of other people's nefarious actions, I would use the word. And this current owner purchased it. Apparently, I'm unaware of what was illegal there. This accessory dwelling unit is bigger than my story and a half house. You know, I'm just roughly doing mine, and I'm saying I got about 12 or 1,300 feet in my story and a half house with 3 bedrooms. So I think that it's unfortunate this occurred. I think that we should grant the variance, but I don't think that we should limit it to 1 bedroom. If you could have 2 people, and for one person having health problems, like my wife has a CPAP machine that sometimes keeps me awake, you could have a couple who use 2 bedrooms just for their own ability to sleep. So I don't think that 1 bedroom should be limited there. If it's allowed 2, I think that should be there. I do think the attorney had a very good point that if sometime later down there, this was to be approval for a subdivision by the planning board, that they would remove that accessory dwelling. And I think that's a fair give and take on their part. So other than that, those are my comments. I think that you shouldn't limit it to 1 bedroom. And I think that if they put that stipulation in, if it is in the future ever subdivided, that it would remove that structure. But I also think that you should keep in that item about rentals at least a year or greater.
I guess, Ron, John, how do you have comments?
No, I hear what everybody is saying. I'm kind of in the same vein as Russ. I applaud the applicant for coming forward and trying to straighten this mess out. It's unfortunate that somebody dropped the ball someplace along the line, or somebody did the wrong thing, but that's the nature of humanity, I guess. I feel that you know, we have to give the applicant the benefit of the doubt that they're not going to immediately turn this into a short-term rental. Certainly, there's a process that they would have to go through and have yet another renovation to meet those requirements. I guess I'm satisfied that the property is restricted by the driveway itself, and I don't feel that that are any conditions that we can place on it. You know, we are not legislative, but we can place certain restrictions, but I don't think anything would be so hard and fast that a person couldn't change the nature of the property completely, given enough effort. So I'm satisfied taking it. They want to become, you know, reputable members of the community and blend into the neighborhood and not cause any troubles. And I guess I have to take it on its face.
Ron?
Let me save a bit of time here, Charles, and say that everything that I was going to say has been said, so I will not say it again.
Thank you, in the interest of time. I will just say, I think that my fellow board members know that in general, I prefer to try to limit conditions. I think the point here is to decide whether or not a variance is warranted. I am convinced it is. You know, the town went to a great deal of trouble through a lot of public hearings and a lot of discussion to come up with a short-term rental law that tries to address the concerns that I think, you know, many residents of the town have. I agree with John's comment that there are both positives and negatives. I think that accessory dwelling units are very important. I happen to be sitting in my family home in Rhode Island next to an addition we built for my grandparents 50 years ago. They're no longer in it, but you know, it's it's an important part of the property. I understand why landowners with a large parcel often wish to have someone else on the property, particularly if it's a family member. And so you know, my predilection would be to not it's very hard to enforce conditions in variances. They get lost. It's, it assumes that somebody's actually checking, but so and I agree with Russ that limiting this to one bedroom seems counterproductive. I think it just, the code allows 2 bedrooms in an accessory dwelling unit, and that would be my preference. So we're going to have to decide, we're going to have to vote on amendments because we have a proposal from Norma for limiting subdivision and as number 5, and we also have my proposal would be, I would like to make a motion, an amendment to remove condition number 2, that there be only 1 bedroom. Arthur?
I already struck it out.
Thank you.
I also struck out the rental 1 year.
Yeah.
At sublets. I think the sense of the board is those are restrictions that are not really appropriate considering our other laws.
And Norma, what's your position on the subdivision as a condition?
I can see the credibility to not limiting it in perpetuity, and I think that because that's can be a long ways down the road, but I do like the condition that the building be removed, the accessory dwelling unit be removed if it's subdivided.
So that's a motion. I would second that. Are others in, who's?
You motion, who's the second? You the one who motioned. Who's the
I
second?
motion, so I need a second for,
Yes.
I'll second it. I'll
Second.
second that.
all in favor of that amendment?
What, can we be specific on?
I think the motion is that if the property is subdivided, the accessory dwelling unit will be removed.
That doesn't refer to the building, just the dwelling unit.
Yes, it could be converted back to a pool house. Does that fit, Norma?
If I may, my thought is if it's added as a condition of the variance, at the point anyone goes to make an application for subdivision approval, this record would be found at that time. Therefore, it's not going to be like some other conditions that do have a tendency to get lost in the shuffle. That would definitely come to light at the time any subdivision application would be made.
We hope.
But also, there once the variance is approved, they have to get a special permit for the accessory dwelling. When the planning board addresses the special permit, then they're gonna look at it. It's 31 acres. If they ever subdivide it, those 2 dwellings has to stay within 10 acres. And the rest,
So can I see a show of hands on whether you approve this addition as a condition?
Could you restate it there? You mean if it's divided, then it'll be removed? Is that what you're talking about?
As it will be removed as an accessory dwelling unit.
Yeah.
I think I saw 4 hands, so I guess that condition's been added. So Arthur.
wait, I need everybody aye or anybody nay? Can I
Nay.
do roll call?
Nay. Nay.
Okay, 1 nay. Norma, your vote?
Aye. Borderline.
Okay,
Ron?
so we
Wait,
have,
I'm sorry, Ron, are you aye?
Yes, thank you.
Everybody's aye, okay.
except Arthur is a nay. Okay, Arthur, do you wanna-
Can I input this?
Sure.
Thank you.
Art, can you add the condition about fees?
All
Fees,
fees all
Yeah.
fees have been paid.
yes.
I will add that just a minute.
Also, did you put that this is in the AR something? We have to put that in the
I
resolution.
muted you because since I'm trying to type, I thought it would be
Okay.
better. And you can mute me now if you like. My apologies. Arlene, you had another thought to share?
The AR, the zoning district, it's not in the resolution.
I don't know why it has to be in the resolution.
Probably could add in the first paragraph,
Why does it have to be there, and where do you want me to add it?
because in the future, it always, it always play this way, especially, with accessory dwelling, whether double the acreage and it's they subdivided,
Mm.
we always do.
Yeah, I mean, whatever. I'm being a little hesitant here. Motion to Rip Road, good number, and variance in this AR.
I think we have to go with the more restrictive one. And so I would think this should say AR5.
That's what I'm typing. Right, I think I've got that good enough to not lose track of it. Okay, so we're still with the conditions. I've added a condition, and we have at this point 4 conditions.
You want to read them for us, please?
Yes, first condition is all fees have been paid. Is that sufficient, Arlene? All right. The second condition is the pool shall be fenced from the accessory dwelling unit and upgraded to code 257A. A latch is not a lock. A lock requires a key or code. I was not really aware of 25074's protections. The current dwelling, the current building has immediate access to the pool. So the pool is not really fenced off from the rest of the property. It opens right onto what will become a dwelling unit. Having had a relative with the child drown, this is not a good situation. This updated code of 25074 includes alarms for children in pools at the pool side and as a remote alarm. So I am concerned that the pool is not fenced from a dwelling unit.
Well, I think you've said that in the condition, and so I think that's what the condition is.
I just wanted the board to understand that. It's a bit of an aesthetic challenge to the owners, but nonetheless, I think it's a major safety feature. And then, okay, so that's number 2. Number 3 is the signature of all LLC members to authorize shall be obtained and presented. Number 4, if the property is subdivided, the accessory dwelling unit will be removed.
Thank you. Are we ready to vote?
Yes.
So I will ask, I'll call the names of each member of the board and ask for your vote on the motion. A vote of aye is to approve the motion. A vote of nay is to deny it.
Did anybody second my motion yet?
We seconded at the very beginning, as amended. Can I get a second for his motion?
Second.
Thank you, Ron. Okay, Russ, your vote.
Aye.
Ron,
Aye.
John,
Aye.
Norma,
Aye.
Arthur,
Aye.
and my vote is aye. Thank you for your patience. Your variance has been approved, and good luck with the renovations. I too want to applaud you for fixing this and getting this right. So thank you very much. We need to move on because at midnight we all turn into pumpkins. Under the governor's order, this meeting has to stop. We are no longer allowed to do these meetings, and we still have 4 to get through. So we're going to try to move along here. So thank you very much, and we'll move on to the next, to DeMello and Clark. So let's see, who do we have representing the applicants for this? Darren,
That's
hello
me.
again.
Yes, Darren Davidovich from the Art of Building here tonight.
Yeah.
Very
So
good.
you want to go ahead and talk us through this?
Certainly. So just by way of background, 13 Mountain View Road, 10.41 acre parcel in the AR5 zoning district. And we were here just a few months ago, back in March, and we were granted 2 different variances for this property. And we're back tonight to talk about the former poultry shed on the property, which we are in the process of converting into a garage. And the reason for that is because it does not meet the 100-foot front yard setback for the zone. We only have 56.4 feet from the road to that building. Yeah, right there in yellow is the building on this map. And just a little bit more by way of background, we had actually started construction on this building back in, when did we actually start? In March 29th. We started to renovate this building or reconstruct this building. And that was done under building permit 2021-7200. I know there's some confusion as to what permit was issued for this, but it's 2021-7200. And that permit was issued on January 11th of this year. And along with that permit, we had submitted a set of plans dated 11/23/2020. And those plans show that the building was to be reconstructed. It shows a new building, it shows footings, and it shows the building being used as a garage, albeit largely the same building, just put to a more productive use for modern times or for what the property owners actually use the property for. And that work, like I said, started back in March 29th. And the work then stopped. I think it was May 5th. It might have been May 4th or May 6th. The zoning enforcement officer and the building inspector asked us to stop work on the building based on a complaint from a neighbor. So we are here tonight to try to get back on track. We started the work with a building permit in hand with good intention, and certainly realize why we're back here. The building not meeting the setback requirements. And I know the first question is, what are the proofs for the variance? So I can talk about them briefly. For starters, the building that's being replaced here, the replacement is 100% within the footprint of the old coop or poultry shed, as it's sometimes called. And it is no closer to the road in its new form than it was in the old form. We've done our best to recreate the same building. Also, the building, if you look at the architectural plans that have been submitted, does a lot to retain the agricultural feel of the building. Very similar materials, very similar massing, very similar windows on the back of the building as it faces the road. Similar color, and pretty much everything we could do to make it still look like a chicken coop. The building is near the road, as we've established, 56.4 feet. What's hard to tell from this plan is that there's a pretty good amount of grade separation. Mountain View Road actually climbs as you drive from west to east. So it's a bit difficult to see up towards this building thanks to a berm on the side of the road. And we've done a little bit more to conceal the building to keep its profile very low. We've actually designed it with additional concrete in the back wall so that the building grade can be brought up around it, and the wood section of the building appears to be much closer to the ground than it actually is, because some of it is, in a sense, subterranean. Another important point is that the building is behind the front plane of the house. When I was here last, we talked about the house being too close to the road. This building is actually another 18 feet behind the front plane of the house. The house is about 38.4 from the road, and this building 56. And in terms of nonconformity, no increase in the nonconformity of the building. And basically it's a building that's been in this location. There's been a building in this location since 1974, which is the best dating we can find on the original building. And, probably the biggest question that came up when the planning board referred us to this board was, you know, if you had to replace this building starting from scratch and there was no precedent of another building, would this be a good location for it? And as terrifying as that thought is to both us as contractor and the property owner, I think the answer is absolutely yes. I think it does a lot for the character of the property. I think, you know, the coop being on the road, reading as an agricultural building, is something that's been the case for a very long time. There's a relationship between the structures on this property. You know, coincidentally, they're almost about 100 feet apart from one another. So there's this nice little relationship that these structures have with one another, all being spaced fairly evenly across the site. And, you know, the feel of the building, the feel of the property behind it, I think would be changed a lot if the building were to move a full 100 feet from the road. I think it would be kind of crammed up against the barn. And I think you lose this space that exists between these two structures, the barn and what's called the coop on this plan, and this very long view. As you climb up the hill from the main house, there's quite a bit of grade change as you get from the main house to these two buildings. There's a nice long view out to the paddock that these buildings just help to punctuate.
Great, thank you. Norma, do you want to take over?
Sure. I was trying to keep track of the number that building permits before I get going. I couldn't like dig through everything because I have a lot of emails here. But what I have is a memo that when we get up for our discussion, Arlene, if you could either put up the building permit that was referenced or the March 23rd memo when the time comes from Mr. Davidovich, okay, on the poultry shed. But I'll read the planning board motion first. Is that what you like, Charlie?
Please.
Okay, there's a minor confusion with the parcel numbers, so I'll just read the correct number. It's just a typo. Okay, and this is a motion made on June 2nd this year, and the Town of Clinton Planning Board, Mr. Auspitz motion that the Town of Clinton Planning Board is making a positive recommendation to the Zoning Board of Appeals on the requested area variances to section 250 attachment 2, reducing the front yard setback from 100 feet to 56.6 feet to permit the construction of a 3-car garage as requested by Michael Clark and Charmaine, I hope I said that correctly, DeMello, on property located at 13 Mountain View Road. Tax grid number, the 6 important digits in the middle are 070730 in an AR5 zoning district. The applicants, Michael Clark and Charmaine DeMello, seek a recommendation from the planning board regarding their request for an area variance to permit construction of a garage 56 feet 6 inches from the road, which is 43.4, 43 feet 4 inches less than the 100-foot setback required by section 250 attachment 2. The property in question is in excess of 10 acres and is located at 13 Mountain View Road in an AR5 zone in the town of Clinton, and it repeats the property number 070730. The structure in question was formerly a large chicken coop. Applicants proposed to construct a 1,011 square foot 3-car garage, which they state will have the same footprint as the former chicken coop. The coop has been demolished. Construction on the garage was substantially advanced with a foundation laid and the building frame when it was halted by the zoning enforcement officer for lack of an area variance. The proposed structure will not produce an undesirable change to the neighborhood. Applicants state the garage will be designed and graded to minimize the perceived size of the building. The proposed building is the same size and in the same footprint as the prior structure, the applicants assert. The height of the new garage will be 11 feet 6 inches compared to the prior structure of 9 feet 2 inches. The new building will be painted in dark colors to tone down, in quotes, the appearance of the building. The applicants will plant a mix of evergreen and deciduous trees between the building and the road. Number 4, applicants state that the benefit could not be achieved by other methods because it is officiating pre-existing nonconformities. However, once the prior chicken coop was demolished, am I missing some? The proposed garage could have been located 40 feet further back on the property and the new driveway extended to it, thus avoiding the need for an area variance. Applicants state that the location of the building serves as a visual and sound buffer for the property. Without it, the feel and look of the site would be compromised. Number 5, the proposed change is substantial. While applicants argue effectively that the footprint will be the same, the fact is that a new large building will be created. The difficulty is self-created. We note that the applicants previously sought and the planning board recommended an area variance for their main house, which is also closer to the road than permitted as a pre-existing structure, which they proposed to modify. In contrast, they did not seek a similar area variance for this garage, which also replaces a prior non-conforming structure until the issue was called to their attention after the new building was well underway. The variance will not have an adverse effect on the physical or environmental conditions in the neighborhood. The prior structure was in need of substantial repair or demolition. Number 8, while some of the considerations for a variance set out in 250-98 are either not met or are close to questions, the planning board concludes that a totality of circumstances favors a variance. A new garage is at least as good as an old chicken coop. And it goes now therefore be resolved. And it's the end of the planning board motion.
Thank you. So Norma, do you have, questions, comments you want to lead off?
I was just confused by one thing because I know I've got so many papers here, I couldn't follow. Mr. Davidovich said that he submitted plans showing a garage on a certain date. And
I'm sorry, is this what you need?
all I pulled out was,
Norma,
thank you.
hear me?
I can hear you, I'm reading it, so I can tell if that's what I'm looking for. Is this the permit? Mr.
That's the one I was referring to, if I can interrupt. And then the set of plans that accompanies this is the one with that date of, I'm looking at them right here. 11/23/20.
Okay, well, the one I pulled out from, I just want to straighten this out because the one I pulled out of here on March 23rd, 2020 was for an application for a storage shed. So somewhere along the way, I got confused. Help me out here.
Yeah, well, there was originally another concept intended for this building, which we submitted an earlier permit for. So I think there's some confusion between those two. And that would have just, essentially they were going to use it for storage, just clean up the siding and the roof. And that was like $15,000 worth of work. There you go. And then we submitted a second application and that had $100,000 worth of work, which is the full set of plans with the garage shown and the footings and so on and so forth. So it actually calls it out as reconstruction of existing garage. So this is a scrapped concept. So in effect, we do have two building permits issued on this building.
Okay. So, but you have not obtained a demolition permit for the old structure?
We have not. So we've submitted both demolition permits. There's one from the building department and there's one from the planning board. So both of those applications have been submitted. And it's probably worth noting that, the intent here was, even though we submitted a plan for a full reconstruction showing footings and, a complete replacement of the building, essentially, the hope was that we would have been able to use some of it. So submitting the most intense version of our idea. The thing that might have to happen in the worst case scenario was what we did. And there was some hope that we could have used the footing. The plan was that from the exterior, at least from some of our excavations and some of the corners, it looked like a more substantial footing and slab under the building. And the thought was, if we could have done some shallow frost protection around it, it might have been enough to put the garage on. But then as we started into the demolition, it just became pretty apparent that there was really nothing left of it. And as the sunlight hit it, it was just full of cracks and very inconsistent in its concrete thickness. And, you know, also worth noting is that I did put a call into the zoning and enforcement officer. You know, at that moment, the demolition took essentially a day. And during that day, I gave a call to the building or the zoning enforcement officer just to say, you know, do we need some sort of demolition permit? You know, here's where we're at. You know, I was hoping to save some bit of this so that it wasn't a complete replacement. But I didn't get any indication that we did at that time.
Okay, so this is the $15,000 application. Arlene, I think we need the $100,000 one.
Oh, yeah, everybody said that. So you're gonna have to update your building permit, Darren. This is not worth 15,000. Everybody's telling me that.
No, there's another one for 100, which is the second permit you had up on the screen. There's two. This is the earlier one. And in fact, I've actually submitted a more recent version of the plan and an even greater budget because they've done some things to enhance the cost of the building along the way. Same building, but.
So Norma, are you comfortable that the building permit issue is sort of wrestled to the ground?
If the rest of the board is,
Yeah, I mean, I take your point.
we saw it earlier.
Yeah, I take your point that the demolition permit is clearly needed here, but that seems underway as well.
I have the application. He's gonna be on the next planning board agenda for that.
Great.
Okay. Well, I could see where, with the way the road is curved there, as not that there's a lot of traffic in that section of the road or even all the way along that road. But if somebody did come along at night, it would prevent headlights from shining into the house, which would be very beneficial. It's
Okay,
Where's the 100,000?
Arlene, I think you can bring us all back on the screen.
Just
there
showing
you
the 100,000.
Yeah, and this is going to be updated, so I think we're probably past that, so.
Okay.
Norma, other issues, or should I ask the rest of the board if they have questions?
You can go ahead and do that.
Yeah, other members of the board, do you have questions for Darren?
My only concerns would be it obviously, I can see that they were issued a building permit, but the building permit, if I read it, said renovation, and I don't think it's a renovation. I think it's a replacement. So it seems like what was needed was a demolition permit to remove the chicken coop and then a permit to put a new building in place of it. So it seems like the words renovation or restoration, maybe that was the intent, but that wasn't what occurred. And you can see that the construction is entirely new. So it's to my way, not a renovation or a restoration.
My sense is that that's being rectified by applying for a demolition permit and a new building permit that, Darren, what's the term used in the new building permit?
Well, I definitely have to take responsibility for the poor use of our words here. The plan that we submitted with that $100,000 building permit certainly had the header reconstruction of existing coop. And it was my handwritten application that used the term renovation. And then I went on to elaborate on some of the more significant details just to make sure it was clear, you know, it's going to get taller, it's going to have new siding, new roof as well. So I've been thoroughly reprimanded on my use of our words, and I've definitely learned a lesson.
I didn't holler at them.
Yeah, and clearly a demolition permit implies demolition, and so I think we can move on from the semantics here. Other members have questions for Darren?
Darren, you probably spoke to it early on and I missed it, but I'm still struggling with the orientation of the building with respect to the road. Is the what I would call the rear side of the garage the shorter side?
It is, yes.
Road facing?
Yep. So the road facing side is the one with the row of windows. They're sort of off center, just taking inspiration from the former chicken coop. And then the garage doors actually face inland on the property. So, one of those things we're aware of that's fairly taboo in most towns is having garage doors face roads. And then this also sort of creates a nice parking court situation for the owners and meant we could keep the grade on the roadside much lower because cars wouldn't be able to come up from Mountain View Road and get into garage doors on that side of the building because it's about 6 feet out of the ground. So you couldn't get it, even a reasonable car in there.
Okay, I thought so. Thank you for confirming.
Any other questions for him before we open the public hearing? If not, I'd like to make a motion to open the public hearing.
Second it.
Thank you, Russ. All in favor?
Aye.
Aye.
Thank you. So do we have any questions or comments from the public? If,
Bonnie's here, Bonnie. Bonnie.
Sorry, I did ask to be present during the meeting because this is property across the road from mine, and I kind of wondered what was going on, and I wondered about the 100-foot setback, but I think my questions have been answered. I will say that the projects over there seem to be done with great care and no expense spared, so I have faith that they will do a good job to make sure that this isn't certainly an eyesore. I might like to see some shrubbery or something between this former chicken coop and Mountain View Road, but we'll see how it looks when it's all done. I mean,
there was just, I'm pretty certain I heard Darren say there were going to be plantings.
yeah, but on the picture that you showed, I didn't see any. There were plantings around the other side, but not between the road and the chicken coop itself. I do agree that the chicken coop that was there was very decrepit, and carrying it down was probably the wisest move. So I was curious.
Thank you.
If I could just respond to that, yes, absolutely, shrubbery between the building and the road. So I've stated on this record, but it was also written in our application, and Norma read it as well.
Great. Any other comments or questions from the public? If not, I'd like to make a motion to close the public hearing.
Second it.
Second.
Second. Thank you. All in favor?
Aye.
Aye.
Okay. Norma, any further questions or comments from the board? If not, I'll ask Norma to read her motion.
I just had a question about I call it a map that they showed with a layout showing soccer field, and I think it looked like a running trail around it. And I was trying to figure out I can't envision homeowners having a soccer field. There's not enough to play on a team. So I kind of look at that and say, what's your idea here?
It's actually the septic field. So we're in the process of getting a new septic system approved for both the house and the stone cottage, which is proposed to be converted to a dwelling, a detached dwelling. So that requires a new septic system. And just for the kids, it's a soccer field. They can play, games on the top of it. It's going to be essentially lawn in the middle of the paddock. So we just sort of embellished it to get the kids excited. The homeowners have 2 young children, but nothing regulation, nothing, open to the public for sure.
Well, like I said, I saw it looked like a running track around it, and I said, I don't know what their children's ages are.
That's for the homeowner. That's for, Michael. The idea is basically what we have is a bit of an orchard moment there on the road. So weaving in just a mulch path or gravel path, through the woods. So he can go out of his home gym and do some running in nature. Again, nothing particularly developed, just enough that we move a few rocks out of the way and put something soft down to run on.
I do remember from the previous variance drawings that showed for the accessory dwelling unit and for the main house that you were making completely new septic system, probably with a pumping level. And you say
Correct.
that's going to be where the soccer field's going to be?
That is, yes.
Okay. Thank you.
Okay. Thank you, Arlene. Norma, your motion.
My motion, and there's one little edit in it since I emailed it. I just added one line about the critical environmental area. You'll see it as we get along there. I hereby motion to approve the area variance. The applicant wishes an area variance to section 250, attachment 2, reducing the front yard setback from 100 feet. And I made that 55 feet instead of 56 inches.
6.4, sure.
Yeah. And then I changed, which is 45 feet less than the 100-foot setback. That adds up to 100. The other numbers didn't add up to 100 anyway. So just kind of rounding them off for a few inches,
Sure.
just in case. We've done that before. So less than the 100-foot setback, to get back to that, required to permit the completion of the replacement of a demolished chicken coop with a 1,100 square foot 3-car garage as requested by Michael Clark and Charmaine DeMello at 13 Mountain View Road, a 10.48 acre property, tax grid number 132-400-6368-00-070730 in an AR5A zoning district. An undesirable change will not be brought about in the neighborhood. Applicants state the garage will be designed and graded to minimize the perceived size of the building. The proposed building is using the same footprint as the prior structure. The height of the new garage will be 11 feet 6 inches compared to the prior structure of 9 feet 2 inches. The new building will be painted in, I added muted dark colors,
Sure.
give a little more
Absolutely.
latitude and just toning it down, okay? And in fact, it was stated to tone down the appearance of the building. Applicants will plant a mix of evergreen and deciduous trees between the building and the road, which is not on the diagram, okay?
No.
Number 2, the planning board gave a positive recommendation on June 1st, 2021. Number 3, the benefits sought by the applicant cannot be achieved by some other feasible method besides granting the variance. Number 4, the variance is substantial. 5, the alleged hardship was self-created. 6, a residential area variance is a type 2 action under seeker and requires no further action. 7, the site is not in an ag district and a residential area variance does not require an ag data statement. 8, the site is in a ridgeline scenic or historic protection overlay district. And then I changed the next one to 9. The site is not in a critical environmental area. 10, per the zoning enforcement officer, no demolition permit was issued for the chicken coop, which is section 250-93, but there are no known other zoning violations on the property. Okay. And number 11, all fees have been paid. And on the condition, I have here, obtain the demolition permit, which Mr. Davidovich said is already in progress to ensure proper town records.
Thank you. Second for discussion?
Second.
Thank you.
Yeah, sorry, I didn't mean to. My copy of Norma's motion has 2 other conditions mentioning the exterior lighting shall be downward facing and no storage on the exterior of the garage.
Oh, sorry, it's on the next sheet. Yes.
So Darren, I see whether he hears his name.
Yep.
One of the things that we tell applicants, which I hope you can pass off to the homeowners, is there's no storage in the setback. And just because we've got a garage in the setback that doesn't mean that you can lean a wheelbarrow up against it or many other things that people normally think to do around buildings. So they just have to please be aware of that. And if you could pass that on. The same would go for other setback areas if there are others. That's, I just wanted to pass that on.
Certainly, yeah, I'll pass it on, and I heard the downward facing lighting as well.
Great. Any discussion, or are we ready to vote on this?
Wait, Nora, can you switch the fees to the condition, please? Because I still have to collect publication fees.
Oh, okay, you still have to collect those?
Yes.
So, shall I just put it,
Just
Hey.
arrow.
pay all fees and take away that all fees have been paid?
Or you could put it on the condition and then that would take care of it.
All
Just put an
fees,
arrow to number 4.
all fees to be paid?
Yes.
All fees to be paid, okay. And then I'll strike number, I'll strike that last line out from above regarding the fees.
Sounds good.
Okay.
Any discussion before we vote? Seeing none, I'd like to, I'll poll the members. Russ, your vote?
Aye.
Ron?
Aye.
John?
Aye.
I have to go down my list. Norma?
Aye.
Arthur?
Aye.
And I vote aye. So the motion carries unanimously. Okay. Thank you, Darren.
Yeah, thank you, everyone. I appreciate your time.
Okay, take care.
Good night.
Good night. Okay.
2-minute break,
Well,
Charlie,
three-
please.
Yes, I agree. So I'm gonna ask for a 5-minute break, 4-minute break. It's 9:11 by mine.
Yeah, we still have 3 items, Charlie.
Yeah, I know.
Clock is ticking.
They're very thin.
Yep. So let's, anybody who needs to, please take just a couple of minutes. Let's all get back as quickly as we can. I'm gonna take a break too. So Ron, you'll be up next.
Oh, I didn't realize that. I thought Freisetzer was ahead of me. No problem.
Well, mine has you next.
Yep, you're correct. I'm mistaken. Thank you.
And given all the files and folders, it helps to have some warning.
I definitely need more desk space. I could say that.
Yeah. Okay. Oh, we were all back.
We are.
I got out just long enough to ask my wife to bring me a bowl of ice cream, so my apologies. If this were first grade, I'd have to bring enough for everybody, but it's not first grade, so you're all on your own.
I'm
That's
in
not
courtesy,
fair.
Charles, really.
Oh, okay. Our next is Carolina Wallison. Is that, you want to tell me if I'm pronouncing your name correctly?
Yes, that's correct.
Thank you. Welcome. Do you want to just briefly describe for us, why you're here this evening?
Okay, I'm just asking for approval for the setback requirements in my backyard to have an above ground pool put in.
That's admirably brief. Ron, do you want to read us the planning board and get us started?
I will.
Let me just say that it's also perfectly acceptable to simply summarize the planning board decision in the interest of moving this along. So,
Okay, well, duly noted. I'll be as brief as I can, Charles. In a letter dated to Ms. Wallison on June 4th from the planning board with regard to her request for a rear setback variance from 75 feet to 16 feet for a property located at 150 East Cookingham Drive, tax grid number ending in 480576 in an AR5 zoning district with 9 stipulations or 9 points, all of which I will cover in my draft motion. Basically, was unanimously approved by the planning board, vote of 6-0. Is that sufficient? Is that a sufficient enough?
yeah, I think that's perfectly fine. As you say, you're going to cover these issues in your motion.
Yes. I was able to visit the property, meet with Ms. Wilson. Arlene, if you wouldn't mind, could you put up the well, we can look at this briefly since this is here. The shed that is currently shown on the left-hand side of this diagram is currently in the footprint of the pool. The shed will be relocated to accommodate the pool. The area where the shed is proposed now wouldn't be sufficient or wouldn't suffice for pool location. The ground is sloping there, as is most of the property left of the home and front of the home. So in short, I will say that, if one were to consider installing a pool, this is about the only location that would suffice. Arlene, if you could put up the parcel access card, I want to just explain a little bit further as to why this location is more suitable, because it will come up in some correspondence from neighbors as well.
Yeah, hold on. Let's see, ready for that.
Sorry to blindside you with that. While you're looking for that, I'll start to
Yeah, go ahead
detail
and.
why I bring that up. To the right of the home, East Cookingham Drive is parallel to the front of the home. As you travel up East Cookingham, it makes a 90-degree turn to the left. So the side yard, as I would call it, is in fact suitable in terms of grade. However, it would be more visible to many more homeowners and passersby in that neighborhood. The area I'm referencing is right under the S in parentheses there after 1.04 acres. Exactly. Thank you. And the reason why I bring that up is because there is some correspondence from two adjoining property owners. I'll read those now if that's appropriate, Charles.
Yes.
Okay. And a email correspondence to the board dated June 23rd. Says, hi, I am Dale Lasco, who lives next door to Carolina Willison, who lives at 150 East Cookingham Drive, who is waiting to be approved for a variance which borders my property. I would like to view the video meeting on the variance Thursday, June 24th. If approved, I would like to make clear that the 16-foot variance is determined from the closest outside perimeter of a pool from my property at 134 East Cookingham Drive. Also, I would like to recommend that shrubs, fences, or trees be used to promote privacy between the two properties. Thank you, Darrell Lasco, 134 East Cookingham Drive. We have a second correspondence submitted by a Blanche Gordon, dated June 23rd as well. And I'm reading this verbatim. Dear Sir or Madam, my name is Blanche Gordon, the owner and occupant of 162 East Cookingham Drive in Statsburg, New York. I write in response to a variance application requested by Carolina Willison, Andres Willison, and Dorota Willison, residing at 150 East Cookingham Drive, property tax grid number ending in 480576. A nursery is located at the premises. The parties seek to install a 24-foot above-ground pool. They request a variance to section 250, changing, parentheses, reducing the rear yard setback zoning regulations from 75 feet to 16 inches. I'm sure the intent was 16 feet there, just a typo. The parties note that the area is located behind, in quotations, the house. It sounds like a negligible change. However, the property is located at a unique location on a curve at the center of the neighborhood. All the areas of the property are visible to all residents. In fact, the back of the house is actually the front of some of the properties. Any change to the property characteristics is a negative impact on the value of my property and surrounding neighboring property values. A nursery should not have been permitted at that location to the detriment of other longtime residents. There is constant traffic and disruptions. The nursery is more suited for the center of town, Rhinebeck, High Park, or perhaps next to the town of Clinton Town Hall and Library. I write in opposition to the application. I urge the board to reject the application, as an above-ground pool at that location would be a liability to the town. It will devalue property values of the surrounding properties, and it will be a disruption to the serenity and tranquility that we are accustomed to. It will also be, excuse me for saying so, an eyesore. Thank you in advance for your time and attention to this matter. Sincerely, Blanche Gordon, 162 East Cookingham Drive.
Thank you. So do you want to lead off with any, do you have any questions for the applicants?
I don't have any questions for Ms. Willison. I will relay to the board that, as I said earlier, it is, to me, if one were to install a pool, the most suitable location to do so. And, you know, of note, there are several other above ground pools in the neighborhood with mostly, or I think all, in fact, non-conforming lots as well.
I agree. Other board members have questions for the applicant.
Yeah, Russ here. I visited and spoke to the lady and looked at the location. Noted that she said she's gonna move the shed to put the pool in. While I was there, you could look at the map there, the property, which is 482589, has a pool behind his house. That is a neighbor who I believe wrote and requested shrubs or some kind of a buffer put in there. His pool, I'm sure, is closer to the property line than is allowed. So he has a pool which basically I think meets the same kind of process as the pool that this lady's putting in. So I would think that they're almost the same thing. my brother used to live across the street. He had a pool in his backyard. I agree with what Ron said. It's the proper place, and this doesn't show on this picture, but now there is a large board fence going across between the front of the house and the road, which I think obscures view of a lot of this property. And I don't see where it's a detriment at all. And like I say, since the other neighbor already had the pool in very much the same condition, I don't see why the rule should be put on that she has to build something for fencing. She can look over and see his pool, and he can look over and see her pool. And the other complaint from a neighbor, I believe, is not, I don't know exactly where the other one is, but I don't believe it's contiguous with this piece of property. So I think that the application is appropriate. That's all
Russ, I believe the second correspondence I read, that homeowner is across the road.
It's not the one right next to it?
There's
No.
two.
I don't, yeah, the one, the first letter I read, I believe, is what you or I would probably call the
Over here.
neighbor to the rear of the house.
Yeah.
And the other correspondence is across the road, not contiguous to this property.
Yeah.
Is that correct, Ms. Willison?
I believe so. Dale Glasgow, I believe, is my neighbor right in back of me with the pool.
Yes.
162,
It's over here. Lawrence Gordon.
Arlene's showing it now.
oh, she can't even see my backyard, so I don't understand why that's a problem for her. I'm sorry, but she lives on her own. I have kids. I would love my kids to have a pool.
Okay, thank you.
Okay, other questions for Ms. Wallison?
I had one. The shed doesn't show on the parcel access that I can see, but it's on the little diagram as 10 by 20. It's not on their property card. Doesn't that need permit?
I would think so. It's-
120 is the limit. No, 120 is the limit. As long as it's not on the foundation and as long as there's no lighting or something.
Yeah, I believe it is under the 120 square foot total.
Oh, okay.
And it is in fact, it's not on a foundation, it's mobile or movable. It's one of those little, portable sheds that you can buy up in Red Oak there, and there is no lighting.
Okay.
And is the property used as a daycare center?
It's not a center, it's an in-home daycare. Yes, it is.
Yeah, the CEO going back, she went before us and said something about what she's trying to do, and the zoning guys rule it as a home occupation because it's like regular, just trying to watch other kids. It's not like a day center thing.
Okay. And I got one more. Oh, sorry.
Okay, please.
How's the pool going to be filled? Is it accessible by a water truck versus out of the water or the well?
I'm gonna have Gilmore Transportation. They can have access from the road of the side yard.
Okay.
Yeah.
Thank you.
I have a question for the board, I think. It appears that there are 3 owners on the property.
Yes, correct.
Do we have authority to act from the other 2 owners?
You could put it as a condition. The last time I asked her, she said where are they, Carolina?
They're in Poland until October. I can have the form, I can email it to them and ask them to have it notarized there.
That should be a good step in the right direction. If there's any additional questions, we can do it again in the fall.
So I will add that as a condition. That's a good point. Thank you, Arthur.
Any other questions or comments?
My comment is just that I don't find this application troubling since it is an above ground pool. and they generally have a lifespan. It will probably go away sooner or later. If it was for an in-ground pool, it would be, you know, I think the threshold would be a lot higher. So,
Very good point. Arlene, how about, I think we all know the shape of the property. It's nice to be able to see everybody all at once so I can scan and see who wants to speak. So are there any other questions for Ms. Wallison? If not, I'd like to make a motion to open the public hearing.
Second.
Thank you, Arthur. All in favor?
aye.
Any questions or comments from the public? If not, I'd like to make a motion to close the public hearing.
Second.
Thank you. All in favor?
Aye.
Aye.
Okay. Any further questions for them or for Ms. Wallison, or should, Ron, are you ready to read us your motion?
If there are no questions for the applicant, I would actually seek the board's input or advice, because I'm second guessing my language, specifically with regard to the pool itself. Without reading the entire draft motion, it says, for the installation of a 24-foot diameter above ground pool. My intent here was to not see a 26 or 30-foot diameter pool and further encroach on the setback. Should it read for installation of a maximum 24-foot diameter pool? Or is it not critical enough to worry about? What's feedback on that?
I would stick with the 24 because that, that's what
That's what the application is for?
Yeah, if that's what's asked in the variance, I haven't quite, I'm looking again.
Yes, it is.
Ms. Wallison, do you want to?
I actually have I bought the pool already. It's 24 round. I won't get another one.
Okay, so that said, moving right along here, I will read the draft motion as presented. I hereby motion that the Town of Clinton Zoning Board of Appeals grant an area variance requested by Carolina Willison of 150 East Cookingham Drive, tax grid ending in 480576, with respect to the Town of Clinton zoning law schedule of area and bulk regulation, section 250, attachment 2, for the installation of a 24-foot diameter above ground pool. The 1.04 acre property is located in an AR5 zoning district in the Town of Clinton. Factors. Number one, the applicant intends to install a 24-foot diameter pool in the rear yard of this non-conforming 1.04 acre lot and is requesting an area variance from the required 75-foot setback to a 16-foot setback to accommodate the pool placement. 2, the property is in an AR5 district. 3, the property is not within the Ridgeline Scenic and Historic Protection Overlay District. 4, the property is not in a CEA. 5, the variance requested is substantial. However, the proposed location is screened by trees and is the most suitable area on the property for placement. 6, an undesirable change will not be produced in the character of the neighborhood or be detrimental to nearby properties, as this non-conforming lot is among others with above-ground pools also located in setback areas. 7, the applicant cannot achieve the same benefit by another method. 8, the proposed variance should not have an adverse effect or impact on the physical and environmental conditions of the neighborhood. 9, the alleged difficulty is self-created, but should not necessarily preclude its granting, especially in consideration of the surrounding conditions. 10, an area variance is a type 2 secret action under secret and requires no further action. 11, there are no known violations. 12, the planning board has made a positive recommendation to the ZBA for approval. Following conditions would be applicable. All fees have been paid. 2, the pool shall be freestanding with no deck or structure attached. And 3, all property owners shall grant authority to Ms. Carolina Willison to act as authorized agent for this variance.
Second for discussion?
Yes.
Thank you.
I would like to point out the regulations for pools have been updated as of 2006, I believe, when I started researching something else. And that includes the child alarm. I think she should talk to the building inspector to make sure she's in compliance. I know that above ground, the fencing isn't the issue with above ground. As ladder issues and such. I'm not fully aware of what they are. But I think a discussion with the building inspector, would be very necessary.
When every time I have building permit for a pool, I ask alarm, the fencing, and what is it? There's three things. The pool specifications, the alarm. There should be an alarm, and the fencing, the lock. You know.
So there's already a building permit submitted for this, and I haven't looked at it thoroughly, but I don't know if it. But you're discussed this with the applicant.
Yeah, that's one of the before we issue the building permit. Yeah, and before we close it out to make sure, that's the building inspector. Every time he checked it to make sure there's alarm and everything. It has to comply with the recent code.
Thank you.
I just was curious, both Ron and Ms. Wallison, about the condition that the pool be freestanding with no deck or structure attached. Was that a choice by the applicant, or is there a particular reason, Ron, why you applied that condition?
I did discuss the fact that there would be no deck or any type of structure attached to the pool when I did my site visit. And I noticed that there were I don't believe there is any pool in the surrounding area with anything similar. So just to be congruent with everything else, I put it in there. So certainly up for discussion. We can remove it if you feel that it's necessary.
I guess having once had one of these pools, which I have to confess was the bane of my existence, keeping the chemicals up. As soon as my kids no longer needed it, it's gone. But and in fact, the deck that was on that pool is now had the legs cut off and it's just a little back deck. But getting in and out, being able to sit on the edge of a pool and dangle your feet in from a small deck, I think in some ways has some safety features, to be honest. It means an adult can be sitting there on the edge of the pool watching the kids. We certainly wouldn't want this into the setback, but I guess I'm just curious how others feel about this.
Well, the one next door, if I remember right, has I believe a circular deck all the way around the pool. And I could see you wouldn't want to go closer than the 16 foot, but I would think towards the house, you would have maybe a 6 foot square deck or something where you go up the stairs. And like you say, you could maybe have a chair there. So you would have a small deck towards the house, which would be appropriate.
I hate to disagree with Russ, but I was thinking of a half circle facing away, set away from the property line, so it doesn't be. I think supporting the seating area, as Charlie brought it up, and seems like a good step.
So the general consensus is to remove that concession, correct?
No.
Oh.
No, to structure the
condition rather, I'm sorry.
Condition to keep it on the away side of the property line. So it can't go all the way around the pool, but it can be, reasonably substantial. 4 feet.
I'm sorry, I didn't mean to interrupt her. Are you all set, Arthur?
For the moment, yes, thank you.
Okay, I guess I put it in there just because it was a topic of conversation when I visited, and I guess in hindsight now, after this discussion, any construction, be it semicircle, full deck, whatever, we'd be back discussing with Ms. Willison anyway, correct?
We will need a permit, so
right. It would be in the setback anyway. So really nothing, no deck or sitting area would be constructed, without another meeting of this nature. So
well, you would be asking her for all the fees and letters and expenses. Whereas if we do it conditionally now, which is a bit difficult, we could also, can we hold this decision? I suspect she wants to get the pool immediately, but We'll save her all the fees if this condition is now rather than a new variance.
Let me see, Ron, I guess the request here is to reduce the setback to 16 feet. Does that necessarily mean that her building permit can't ask for a deck that's not closer than that? I mean, can't that, I mean, in other words, the building permit is going to talk about a pool. Couldn't it also talk about a deck that didn't protrude any more than that? I don't think it would require a second variance because we would have already granted a variance that it's an odd question. I could see it going either way. So Arlene?
Let me
The
just,
variance that I'm sorry, Ron, but the variance that you're gonna issue at 16 feet is for the pool. So if
Correct.
she puts a deck over there, that doesn't apply for the deck. You're gonna have to issue another variance for the deck. Not unless you put a deck where it's not in the setback.
that was my line of thinking, Charles, in that, this application is specifically for a pool, for one point. For another, the construction of a deck, and we could discuss setbacks and whatnot, but that building process is significantly different with footings, et cetera, and structural integrity. So I think a separate permit with probably a separate variance application would be warranted in that case.
Ms. Wallison, do you have immediate plans for a deck?
I don't think until next year. I don't think I can afford one right now.
Okay, so we could, you can come back before us. I'm happy to defer to Ron on this. If you had initially planned this, you could have applied for both. And then but you really haven't applied for deck. And so really we haven't advertised in that. So I agree. I think Ron is correct here. I was just thinking of my own children's use of this pool 30 years ago. The deck was really, I actually saw it as a safety feature where I could be right there on the edge of the pool if they needed me in there. And so I think it's something for you to consider, but you can come back before us. So thank you, Ron.
But what Arthur was saying about condition, what would that look like?
Well, in that case, Ron, is it necessary to make this condition? Because basically, I think we all agree that if she wants to put a deck in, she's going to need another variance and a separate permit.
Okay, it'll be removed momentarily.
Okay. Any other comments for Ron about the language?
Um,
I see we did lose Arthur.
We did lose Arthur.
Ron, the fees has to be conditioned, please. You know what it is? I have to collect because I haven't received the fee from Poughkeepsie Journal.
It's in there, Arlene. It was the first
That's
one.
the condition.
Yes,
All fees have been paid. There's a condition.
it's there.
Oh, he's back.
So the way it stands now, after discussion, the only conditions will be: 1, all fees have been paid, and 2, all property owners shall grant authority to Ms. Carolina Willison to act as authorized agent for this variance.
Wonderful. Thank you. Any further questions or discussion? If not, I'll call the vote. Everybody's moved on my screen, so I'll start with Russ. Your vote.
Aye.
John,
Aye.
Ron,
Aye.
Norma,
Aye.
Arthur. You're muted, Arthur.
My apologies. I'll abstain because of a computer error on my part. So I didn't hear the motion.
Okay, that's fine. I vote aye, and therefore the motion has passed. But we're happy to take a minute and read it for you, Arthur, if you'd like to.
No, we can move on. I'm generally in favor that it would only be a little thing.
Okay, that's fine. Ms. Wallison, your variance application has been granted. Good luck with getting the pool up and running.
Thank you all so much. Have a good night.
Okay, you too.
Thank you.
Bye-bye. Okay, Russ, you're up next. With the Freister area variance on Browning Road. So who do we have representing the applicant?
Who do we have? Right there. This guy. Artie.
Is there somebody with the label ACSMI?
That one, yeah.
If you're there, you're on mute.
I hope he didn't fall asleep.
Well, he might have stepped out. Why don't we move ahead and we'll switch the order?
No, I'm here.
Okay.
But I'm not for Browning Road. I'm for Deer Ridge.
Oh, okay. Well, let's move
Oh,
ahead.
wait, Simon. I'm sorry. Who's Simon? Oh my God, he didn't show up.
Yeah, I'm here for Doug Simon.
Okay. Okay.
The Freisiters didn't?
I guess not.
Hi
I
there.
don't see him. Can I call her? Can I call the applicant?
Well, please go ahead. We'll jump ahead to the Simon application.
I'm gonna mute myself, okay? Because I have to be on the phone.
Yep, and you can mute yourself, and Russ, you're off the hook for a minute, and John, you're on. So so if the Simons would take a minute to explain the proposal before the board.
Sure, and I guess Art, you can as well, but we recently purchased our house in January, and prior to us owning it, it was used as an Airbnb pretty extensively, and that's something that we're not going to do. We're going to use it for our family and for friends to visit, and we've already been spending a lot of our time there. And because we're very into sports and hope to be able to remain active as we get older, we wanted to put in a sports court on the property. So we've been working with Artie, who's been really helpful to figure out where it should go that's best, where it'll require sort of less impact in the area, and we'll work for everyone and keep away from neighbors and not be a problem. I guess the reason that we need the variance is the spot that we came up is to the right of our driveway as you approach, quite set back, but it comes within 20 feet of our neighbor on one side. Beyond that, there's wooded area of hundreds of feet. I believe one of you visited our son who was staying at the house this week. Yeah, that was, oh, great. Yeah, hopefully he was nice to you. I imagine he was. He's a great kid. And basically other options meant we had to redo the road, and there were going to be all sorts of drainage issues. An area behind the back that was open, that was going to require like massive tree removal to even get access to it. We're going to have to put a road in to get access to where it would be. So after our conversation, with Art and his advice, the area that was marked off with the cones was the best area. And we're hoping to be okay to do it.
But John, do you want to jump in?
Yeah, I'll summarize the planning board motion. Basically, they granted a positive recommendation, and they make a couple of points that it's not a critical environmental area, that the planning board sees that the variance would not have an adverse effect on the physical or environmental conditions in the neighborhood. The homeowners have represented to the planning board that they do not intend to use it as a short-term rental, and that the actual site selection is a good one for a number of reasons. One of which is that there would be less disturbance to the grading in this area than there would in several other possible areas on the property. There are other areas, as the applicant pointed out, but it would create a lot of duress for them and a lot of changes to the property that this site avoids. So they gave a unanimous unanimous vote to recommend approval. I visited the site, and I would say that the planning board's perception was accurate, as is the applicant's. It's unusual to have something like this in the front of the house, but if you look at the configuration of the lot and the driveway, and keep in mind that it is largely downhill from the proposed site to the nearest neighbor and to the road, the visual impact of this project should be negligible, since it is flat. There's nothing much protruding upward except the possible lighting poles. And because of the elevation and the way the lot is laid out, it should all but disappear in terms of any possible view from the road or from the nearest neighbor. And the planning board also pointed out, and I have to agree, that it helps confine the disturbance of the lot to a smaller area than if, for example, it was pushed back into the area where the lot gets wider. So that's my take on the whole thing.
Thank you. Any questions or comments from the board for the applicants?
Well, I visited the site, and I'm kind of amazed looking at the way that property was laid out over there, that they turned around and made those so narrow and so long. The narrowness of it is the reason why it's so close to the property line. It's like, and if behind the house there's a stone wall where you can see with stone walls were usually original boundaries. Whoever laid these things out so long and narrow, I think did a disservice to the owners. And I think that is a reason why this is necessary to lower the setback.
Yeah.
We have the same issue at Browns Pond and lots of the other earlier. Yeah,
They should have made flag lots, you know.
yeah.
I mean, I noticed there are a bunch of flag lots right across the road, so they had a lot of fun laying out the plat map. Somebody was very creative. Other questions or comments for the applicants or for discussion by the board?
I also visited the property and was impressed with the pool house. And as I mentioned in a letter, I think, to the board, it was, I believe I mentioned it, it was originally permitted as a machine shed, but it's obviously a pool house, and the pumps and filters are behind the machine, the pool, the structure. It's a proper classically sized pool house.
Okay. If there are no others, I'm moving right ahead. I'd like to make a motion to open the public hearing.
Second.
Seconded.
Thank you. All in favor?
Aye.
Thank you. Any questions or comments from the public? If not, I'd like to make a motion to close the public hearing.
Second.
Thank you, Russ. All in favor?
Aye.
Aye.
Thank you. Any further discussion from the board before we ask John to read his motion? If not, John, go take us on.
Okay. I motion that the Town of Clinton Zoning Board of Appeals grant a variance from 250 Attachment 2 Schedule of Area and Bulk Regulations to Doug and Diane Simon on their property at 84 Deer Ridge Drive, tax grid number 13240063668, 291160 for a reduction of the side yard setback from the required 50 feet to 20 feet for the building of a tennis court. Whereas the parcel is 10.85 acres, mostly wooded in a AR5 zone. 2, the applicants wish to construct a 60 by 90 foot tennis court. 3, the applicants are seeking a reduction of the side yard setback from 50 feet to 20 feet. 4, the selected site area is relatively flat, so no substantial grading will be required. 5, while there are alternative locations which might not need a variance, the same or more tree clearing would be required, as well as more grading disturbance. 6, the site should not be visible from the road or the nearest neighbor, as the elevation drops from the site towards the road, obscuring its visibility. 7, in making a positive recommendation to the ZBA, the planning board notes that the location of this project centralizes the residence and other entertainment areas to one part of the property, and that the lighting for the court will face east and west and be pointed downward. 8, the request is substantial, a reduction of more than 50%, but that should not preclude its granting. 9, the hardship is self-created, as this is a large parcel with alternative locations, but the applicant's intention to minimize disturbance and centralized development makes this location preferable. 10, there should be no undesirable change in the neighborhood, and the owners have represented to the planning board that they do not intend to use the residence as a short-term rental. 11, the property is not in a CEA, but is within the Ridgeline Scenic and Historic Protection Overlay. 12, per the zoning enforcement officer, there are no known violations on this property. 13, the application fee has been paid. 14, this is a type 2 action under seeker and requires no further action. Conditions: lighting which faces the road and adjoining neighbors' property line shall aim downward.
Thank you. Second for discussion?
Second.
Thank you, Arthur. Discussion?
As the board may realize, I did send a document to the board outlining my opinion that there isn't, as far as I can tell, there is no interpretation by this board. First of all, we don't have the authority to interpret actual regulations, language and such. That's part of what I forwarded. Second of all, no interpretation from the board, as to my knowledge, has been filed with the town clerk. Therefore, the the idea that we continue to reinforce this assumed precedence of treating the pool house and the pool as one unit, I think is inappropriate. I don't wish to do that. I think this is a matter for the town board to address. I'm not sure whether I'll vote no or abstain. I can certainly appreciate that the board, I have no concerns about the setback. I think it's an appropriate position for the tennis court. No qualms about it. As I say, I visited the property because I am concerned about this concept of what pool houses can be. I've had a letter from our zoning enforcement officer who is chagrined to find out that one pool house that we approved is 25 feet from the pool.
Noted. Other questions or comments about the motion? You know, Arthur, do we need to have someone ask us to do an interpretation before we can do an interpretation?
Yes, and Bob Fennell brought that forward as and he calls it a determination, which is certainly, again, in what I wrote to you, the zoning enforcement officer should determine the conditions on property. but not change the code on his own.
Yeah, no, I certainly agree with you that we ought to clarify this so that, so that everyone knows how the zoning board is viewing things. And I don't personally want to hold up the current application on, because we haven't managed to get this formalized, but certainly it seems that we ought to, as a board at a future meeting, sit down and decide exactly how. I mean, is a building 100 feet away? Is it still a pool house? There are certainly lots of aspects of this that, as a board, we ought to work out. And I just wasn't sure if we could do an interpretation without someone requesting it, and we can work that out ourselves. We don't need to take up their time. Arlene?
We have an interpretation before us, a requested interpretation coming at us that Arlene has forwarded to us.
Charlie, can I say Charlie?
Please.
So going back, the town attorney said that the CEO has the power to make a determination. If you don't agree with it, the zoning board or planning board can challenge that determination. But as it stands, if nobody challenges it, that's where it stands. Like a generator, he made a determination, generator is not a structure, it's not subject to setback. So every time somebody is filing a permit, you could put it anywhere.
But just as a matter of principle, and again, it's late and I don't want to tie up this application, but it would certainly be nice for the CEO to know how we intend to view a decision they make, right? I think we ought to be offering them guidance based on our view of the law and the zoning law. So.
And this was submitted to you guys going back with Fennell when he sent all this thing. Nobody challenged it.
Right, and so I'm personally comfortable treating a pool house as a natural adjunct, and so that's how I would end up deciding this. I'm not sure how others would, but I still agree with Arthur that it would be nice to decide just exactly what is appropriate for us to do, again, without tying up the current position. The ZEO has made a determination in this case, and I'm of no mind to challenge it personally. I don't know if others are. So that's where I am. So others, any other, John, Russ, Ron, Norma?
Well, I think it should be straightened out and made clear so everybody's playing on the same level.
But as it stands, you're going to set precedence because we've been treating recently the pool and the pool house are the same, as counted as one. So if you're not gonna do this now, we have a lot of cases where there's a pool and the pool house, that's one. So
I thought we didn't operate on precedents because every case is different.
well,
But
that's
that
a
was,
good thing.
I thought, was one part of our mission.
But
Thank
if the zoning guy ruled that pool and pool house is one, tennis court is two, the other one is, I don't know. It has to be denied first.
But this is certainly something we can talk about as a board and figure out what we think is the best way to proceed.
Another time.
Any other questions or recommendations for changes to John? If not, are we ready to vote? Okay. Russ, your vote.
Aye.
John?
Yes.
Arthur?
Same.
Ron?
Aye.
Norma?
Aye.
And my vote is aye. So the Simons, your variance request has been granted. Good luck with the tennis game.
Thank you very much.
Thank you very much. We appreciate your time and diligence as well.
Yeah. Thank you for your patience tonight.
Very impressive, actually.
It's been a long night. So
I'm glad you people are going to use it for a residence and not have it as a rental.
Yeah.
No intention.
Thank you.
Absolutely. And
Great.
keeping those, what looked like very lovely woods behind your house intact is also a very big plus for me.
I know.
Yes, we're gonna, yeah.
That
Just
all entered
walking back
into the discussion, and thanks, Art. I think you've got the biggest smile of all of us. On that. Congratulations.
Thanks. I'm happy it's all happened now. It's all we're done.
Yeah, yeah. So,
My wife's asking, will we just get a letter that the variance has been granted? What is the process?
Like
Then
that
the
we put on
permit
a
can be
window.
issued. We're gonna move on with the permit. Oh, you have to pay the fees first, the fees. I'm gonna collect the fees, you know, you're gonna get the resolution. Then we're gonna issue the permit.
And do you mail that to us? Is that something that's mailed?
Yes, yes.
Okay, thank you.
And you'll do the same to me because I already have the check cut for you for the fee stuff.
Oh, okay.
Perfect.
Thank you.
Great,
okay.
thanks, everyone.
Well,
Thank you so much.
congratulations and thank you for your patience.
You got it.
Have a nice rest of your evening.
Thank you.
I know.
We're going good. 10 o'clock.
So, Arlene,
It's a no show, I guess. We could go, Marley. Oh, I could go home, Marley.
I mean, I really don't know that we should act on a variance request if the applicants don't show up.
Well, we can't do anything about it. I mean, I called, nobody, maybe they fell asleep. I don't know.
Just for the newer members on the board, in the past, we expected the zoning enforcement officer as witness of his decision to come to the meetings and defend his decision.
Huh.
Which has been helpful in further understanding these actions.
Yeah.
I don't know why that stopped.
No, going back, there was an agreement going back for the CEO to attend the meetings. And you got to remember, we have been different CEOs and all kinds of stuff. So
I wonder if it might have been essentially a financial issue.
yes,
You know, trying to,
yes,
how many hours
Yes.
of effort could we expect? I always appreciated having them there. So,
Who wants to raise our taxes?
don't look at me.
I won't say much coming to mind because it would not be politically correct.
Yeah, no, thanks. So, I guess we can entertain a motion to adjourn.
I have a
Arlene,
question. I mean, is it necessary for the owner to be, he's submitted this, so can't we move without him being present? I mean, we read it.
I'll take a look at it in that, considering that, if you like.
it has never happened in my decade on the board. Norma,
No,
John,
we do that on the planning board though. We do at the planning board, if the owner is not present, if it's a simple application, we do act on it, you know.
I'm about to call up your thing, Russ, and I can't remember if there are any conditions on it. Yeah.
Looking at the planning board here now, and they just have a positive recommendation.
It's a simple one.
yeah, I mean, we obviously have to hold a public hearing, open a public meeting. I'm not, and you know, I'm going to rely on Arthur as our parliamentarian. If there's nothing in the zoning law that requires them to be present, I think we should go ahead and act.
And the owners were notified. Nobody shows up, you know.
Yeah.
It was
Property owners.
Yeah, the legal ad was so the owners certainly received the certified mailing too. So
I would think we should at least go so far as to have the public hearing so that if, I don't know if there's anyone else in the waiting room, but if anyone has come forward to speak, they have that opportunity and it doesn't have to be advertised again.
well, yes, and the point is, it was circulated. Everybody received the notice. The legal ad was posted. So nobody is here on the waiting room.
Well, does anybody, is anybody opposed to us acting on this?
I like what John said, which is to open the public, get it as far as an open public hearing and not negate the expense they've done so far.
I spoke to the gentleman when I visited the place. He was in Vermont at the time. Matter of fact, he kind of jokingly told me to bring my swimsuit and jump in his pool. But I mean, he's knowledgeable, but I can't understand if he submitted paperwork, why we can't act and approve or disapprove it as it rules out, you know?
It sounds totally unlike them. I happen to know them.
Yeah,
They're
me too.
diligent people.
You know, again, I actually often enjoy it when an applicant is brief, concise, and just lets us get on with our business. So
Maybe this is the ultimate case, Charles.
yeah. So, you know, I would recommend that we try to do this, and if we can get it done, I think we could do it expeditiously. And go ahead, Arlene, you wanted to say
Especially
something.
we have a long meeting next one again. Believe me,
Yeah.
I'm trying to fit 5, 6 items on our agenda. Pretty soon we're gonna have 2 meetings in a month.
And Russ is clearly ready to go. So Russ,
Let's
why
go.
don't, does everybody agree we should at least get started, and let's see where this takes us?
Maybe he'll tune in. Who knows?
Yep. Okay, Russ, take us away. Let's get started on this.
All right, so we did have a report from the planning board dated June 16th. And I'll read it real quick. At the Town of Clinton Planning Board held June 15th regarding above subject matter application, following motion was made. Mr. Auspitz motioned the following. Be it resolved, the Town of Clinton is making a positive recommendation to the Zoning Board of Appeals on the requested area variance to section 250-22A for increasing the number of accessory structures from 3 to 4 in order to build a 12 by 24 foot garage / shed as requested by Norbert and Linda Freitzer on property located 48 Browning Road, Salt Point, New York. The last numbers of the tax grid are 392172 in an AR5 zoning district. Applicant Norbert Feitzer seeks out recommendation of the Zoning Board of Appeals with regard to his request of an area variance to allow an additional structure on a 7.7 acre property, 48 Brown Road in the Town of Clinton. Same number. Applicant also owns an adjoining parcel 411129 for a total of 10 acres in the AR5 zone. Applicant proposes to construct a 12 by 24 foot garage shed on a property which already contains a maximum 3 accessory structures permitted by section 25022. Existing buildings are 2 sheds and a pool. There is currently a large tent on the property near where the proposed garage will go. Applicant states the tent will be removed if permission will be granted for the new garage. Proposed site is well back from Browning Road and meets the setback requirements. Applicant states the garage shed will not be visible from his neighbors, and while it's difficult to judge, this may be true since their site has numerous trees. Accordingly, the proposed barn will not produce an undesirable change in the character of the neighborhood. The desired benefit cannot be achieved by some other method unless one of the existing sheds is torn down, which would not solve the applicant's desire for more storage space. The request is substantial because it adds another building. Issue is self-created. The variance will not have an adverse effect on the physical or environmental condition in the neighborhood. Now therefore be it resolved, the planning board makes a positive recommendation to the Zoning Board of Appeals with respect to the applicant's request for an area variance to add an additional structure to the property, subject to removal of the tent described above. And it was carried 6-0. I went over and viewed the property. I called and spoke to the gentleman on the phone. It's obvious from the package that he is purchasing one of these prefab barns like they sell up on 199. Matter of fact, there's a receipt in it for Burt's Barns, I think it is. And you can see an area where they put down some crushed stone, which is common. They bring it in and just set it down on that crushed stone pad. It's right off of his driveway, and it seems like the perfect spot for what he's asking for. And I prepared a motion, so I don't know if there's any other discussion about it.
Yes, there is actually. There is evidently a known violation on the property.
You want to be specific?
Tents are not allowed without, they are considered a structure, last I knew. You can't just put up a tent. If it's 4th. I'm not even sure whether you need a permit to put up a tent.
Where's the tent here?
What?
Where's the tent? I have the map. Can you
Right
see the
about
map?
where you show that orange building.
Yes?
I didn't go to the property, so that's on me, but obviously, it's in the planning board. That makes
thought it-
4 accessory structures.
I thought it
Arthur,
was part.
in the application, the homeowner does indicate that the tent will be taken down. So
So
we could make that a condition.
That should be a condition, yeah, definitely. The first the tent must be taken down. And
Well,
obviously,
it's already mentioned in the planning board. That it says, I just read it, but now I'm trying to find it.
We still have to put it in our motion, I think, though.
Yeah, okay, no problem with that. But like I say, it's basically where you see that orange thing. It's right next to where it's going to be, and you can see the fresh gravel down there, which I believe is where they would set this prefab wooden structure.
in the past, when we have found a violation on properties, I think of seal box is one over. They were definitely made to. We did not act on the variance until the violation had been corrected, and that would be another aspect of, as John had mentioned, going to a certain point and then having the public session open and waiting for things to be put into better shape. Additionally, it's almost irresponsible of a member of the community to not be actually dealing with this issue. I think it would be a bad precedent to go all the way through this without having the property owner show up.
I have to agree with Arthur on that. There might be some extenuating circumstances. Who knows? They could have had a power outage tonight and just can't get online. But if we leave the public discussion open, they'll have an opportunity to speak to us when they come back. And if they feel they've been delayed, well, that it's not.
Yeah.
It's not the board that's doing it.
I'm comfortable with that because I do have a couple of questions for them about, and I'm in Rhode Island, so I have not visited the site, but the property card lists, a bunch of machine sheds that don't really match with anything that's on this map. Often that means the property card is not very accurate, and but it lists a couple of 144 square foot, so presumably like 12 by 12 machine sheds. It's listed twice, built the same year. Are we granting them an additional accessory structure when they've already got a couple that maybe they aren't really even using? So, so I guess I would be comfortable going with what John and Arthur have suggested, and let's try to get them in front of us so we can have a discussion and answer some of these questions.
Should we request that Arlene or the zoning enforcement officer inform them that they have a violation on the property, which can be quickly remedied by taking the tent down?
Yeah, and why don't we go, bring us all back on the screen. I actually think I can see almost everybody, but it's just a lot easier. So I think what I need to do is make a motion to open the public hearing.
Yep.
Yep.
Second.
I'll take one of those as a second.
Okay.
Yeah.
I heard a second. Somebody said second.
Somebody did.
Okay, all in favor?
Aye.
Aye.
Okay, so we have opened the public hearing, and that means we can continue this next month. Is that correct, Arlene?
Yes.
Yes.
So we leave the public hearing open, and I think, Arthur has a suggestion. Arlene, can you communicate to
Sure.
about dealing with the zoning violation and make sure they know that we really would appreciate their presence so that we can ask them questions and do this properly.
It's not a tarp, right? It's a tent, Russ?
It's one of those things you have metal rails put up and then they have it looks like a tarp, but it's green and it's all zipped shut. I have a feeling that he probably has an automobile in it because he said something about putting his vehicle into this new structure.
That's what he said. He said that's the location where he's gonna put the garage. Right now, he's just covering it, because of the rain.
And I don't know what,
So,
I don't know what the requirements are for one of those temporary tents, but I mean, a lot of people have them in their yard.
Yeah, it didn't.
In violation. We have somebody on the Salt Point Turnpike here. It's not only, it's in the side yard. They just, I'll just put a tent up for more space, and they put it right in the side yard.
Yeah. So, I mean,
Like my neighbors.
yeah, yeah, I can point to several of them in my neighborhood. But that's beside the point here before us right now. I believe we could call this a victory and say that we got through all 5, or we got through 4.5 in under 3 hours. So
yes,
I think we all need to, although after I had a cup of coffee and a bowl of ice cream, there's no chance I'm sleeping anytime soon. So
Don't rub it in, Charles. Don't rub it in.
Charlie, my minutes.
So next,
I'm sorry, Arlene. There's no way you can ask us to do minutes after 3 hours of this. I mean, at least.
It's fine. I still have to go home. You guys are home. I still have to go home.
Yeah. Okay.
so next month we will, because we have the public hearing open and haven't closed it, we will just start and say we're still on this case. And because we have contact with the applicants, then we can ask them and proceed through.
Yep.
Should be first up, I think, next meeting. Yeah.
So I better be here.
Yep. And Arlene, I already know that I won't be around for that meeting. I'll be traveling that day. So, well, I have to take it back. I might be traveling through New York and be able to stop that evening in. So let me look
You
at.
better bring us ice cream, Charles. That's
Yeah,
all I can
okay.
say, since you've been teasing us all night.
All right, Charlie, when are you coming back? I know you're still over there because we're gonna be doing
End of August is when we will, when our kids leave town, we'll leave town. But as long as we can see the grandkids, we're staying here. So,
Boy, it must be nice.
yeah.
I'm hoping to get a week away this year somewhere.
Okay, I think I would entertain a motion to adjourn.
I'll second it.
All in favor?
He said he entertained it. He didn't say he made it.
Okay,